Assalamualaikum and good days to our lecturer, Madam Kamilia or Kamalia binti Suleiman, and to all my fellow friends. Today we will be presenting our group project report for course AUD689. The issue that we choose is about Whistleblower Protection Act 2010. My name is Mitra binti Marcellus, and I will be the first presenter for our group. For today, we will be presenting on four content. It is included about introduction, issue on whistleblowing on Malaysia, finding, and also conclusion. Firstly is what is Whistleblower Protection Act 2010. It is an act to promote disclosure of information about any corruption or other misconduct. The Act will provide protection to whistleblowers from any act prejudicial effect of disclosure has been made. It has been passed in Parliament on May 6, 2010 and was enforced on 15 December 2010 in Malaysia. This Act 2010 was enacted to encourage and facilitate disclosure of improper conduct in both the public and private sector. A little bit about whistleblower. Whistleblowing concerns remain the top fraud detection method for providing the initial drive for increasing organizational effectiveness and efficiency in response to management issues. The act of disclosing is known as whistleblowing, and it always relates to private and confidential matters about a company or organizations, which also include details about fraud or unlawful activities at a place of business or employment. The material is frequently sensitive, which could endanger the whistleblower. Survey conducted in 2013 showed that there were still few complaints about inappropriate behavior. Corruptions compromise the government and other essential institutions' ability to provide a level playing field for all participants, which may discourage private investment. Employees' lack of exposure to and awareness of whistleblowing is the cause of this. Only a small number were exposed, and even fewer understood the importance of whistleblowing and how it may help firms. A major factor in the non-practice of whistleblowing, according to opinion, is the Whistleblower Protection Act 2010 incapacity to protect whistleblowers. When whistleblower occur, it occurs when personnel come across organizational misconduct, and it is based on intention and behavior. A whistleblower is also someone who acts to inform authorities or the public when they see their employer committing a wrongdoing or breaking the law. Employees should act to combat corruption by blowing the whistle, even if there is a potential of punishment or even restrictions. Whistleblower participants become very important since an efficient whistleblowing system depends on whistleblower willingness to use the reporting channel provided by the organizations. To further learn about this issue, we aim to identify the factor influencing employee whistleblowing behavior in public sector context. Three things make up this theory. Firstly is perceptions of behavioral control. Second is on subjective norms. And third is attitude towards reporting wrongdoing. Additionally, this study goals is to explore the relationship between the independent variable and the dependent variable whistleblowing intention toward whistleblowing activity, which also serve as a mediator factor for this issue. That's all for me.
Greetings and a very good day to our lecturer, Madam Kamalia binti Suleiman. I am Glenn David Aladin, and today I am going to present what is the issue in the whistleblowing in Malaysia. According to the whistleblowing in Malaysia in 2020, Malaysia has been ranking the 57th country in the world and had involved a few examples of the issues is such defamations, forgery, theft, and any form of corruptions, such as corruption including accepting and giving bribes. While corruption was the main issues had happened in country of Malaysia. The examples of the issues whistleblower in Malaysia is former Education Malaysian Global Services, that is Deputy CEO Wafi Abdul Aziz, aged 37 years old, was charged in September 2020 with causing the sacking of a whistleblower who exposed his illegal misconduct to the Malaysian Anti-Corruption Commission. So on May 20th, 2022, the Session Court in Kuala Lumpur acquitted and discharged the first person charged under the Whistleblower Protection Act 2010 in Section X 711. Judge Susanna Hussain ordered former Education Malaysia Global Service, that is Deputy CEO Wafi Abdul Aziz, 37, to be freed without calling for his defense after finding that the prosecution has failed to establish a prima facie case against him. The court also ordered the bail of the 15,000 to be returned to the accused. From this case, defendant argued that his clients never committed the offense, and the court had clearly seen this is based on the statement that it is very clear that the investigation conducted by MACC was flawed. The whistleblowing process under the Whistleblower Protection Act itself is disorganized, and MACC should fix it. Under these determinants of whistleblowing behavior, it should be improved with the best method of go through the theory of planned behavior. The second issue related to this whistleblowing behavior among public sector employees in Malaysia was the Chief Commissioner of Malaysian Anti-Corruption Commission, Azam Baki, sues the whistleblower for defamations. The argument between the whistleblower was that there is a conflict of interest between business interests and connections. Azam Baki claimed that there is no wrongdoing had happened between the year 2015 and 2016, but the whistleblower mentioned Azam Baki was held nearly 3 million shares in a pair of companies and 2 million warrants throughout 2015 and 2016, which had breached the legal limits for public servants. This issue has revealed the actions of the whistleblower towards a wrongdoing activity among government servants in Malaysia. It's written by Peter in 2022. By using the theory of planned activity, we agree that determinants of the whistleblowing behavior should be improved. The ethic and integrity in the Malaysian WBA 2010. Findings in the whistleblowing in Malaysia. In these findings, whistleblowing is an important medium to prevent and deter corporate wrongdoing. If this form of medium is absent within an organization, it will eventually affect the organization's a costly order. In such sensitive nature of reporting prohibits the study in this field to completely understand what actually motivates whistleblowing act. Under this Whistleblower Protection Act 2010, there are particular rules designed to shield whistleblowers from losing their jobs or receiving unfair treatment. Whistleblower can be either internal or external. Internal whistleblowers are individuals that alert senior staff members of the organization, such as the head of human resources or the CEO, to misbehavior, fraud, or indiscipline. When a whistleblower reports wrongdoings to the parties outside the organizations, such as the media, senior government figures, or the police, this practice is known as external whistleblowing. Therefore, the Whistleblower Protection Act 2010 in Section 711 has been implemented to curb abuses in the public and the private sector, and also this acts as a protection to whistleblowers, which include confidentiality. It also gives power of all the enforcement agencies to carry out investigation of improper conduct and actions against the complaints and authorize the court to make order for remedies. Thank you.
As a conclusion, to sum up, Malaysia established the Whistleblower Protection Act 2010, Act 711, to promote the ease and the report of unethical behavior in both the public and commercial sector. The efficiency of whistleblowing in Malaysia is still constrained by the number of circumstances. Nevertheless, notwithstanding this regulation, one of the key problems is that employees are not exposed to or aware of whistleblowing, which lead to low reporting rates. The Whistleblowers Protection Act of 2010's inability to safeguard whistleblower, which causes them to fear penalty or limitation, is another problem. Whistleblowers are further deterred from coming out in Malaysia, since corruption is still a serious problem there. The theory of planned behavior is the most effective approach for improving the factor that influence whistleblower behavior. According to this hypothesis, three things affect employees' willingness to report wrongdoings: attitude towards doing so, which is towards doing so, subjective norms, and perceptions of behavior control. The efficiency of whistleblowing in Malaysia can be improved by addressing this issue and raising employees' understanding and awareness of the practice. The difficulties with the whistleblowing in Malaysia are highlighted by two recent examples. A former Deputy CEO of Education Malaysian's Global Services, which is accused of firing a whistleblower who reported his alleged misbehavior to the Malaysian Anti-Corruption Commission. These cases includes EMGS. In the second instance, a whistleblower was sued for defamation by the head commissioner of Malaysian Anti-Corruption Commission. This incident highlights the necessity of strengthening Malaysian whistleblower protection law and procedure. The Whistleblower Protection Act 2010 is a start in the right direction towards encouraging whistleblowing in Malaysia, although there is still opportunity for development. Malaysian effort to combat corruption and unethical behavior in both the public and commercial sector can be strengthened by addressing the factor that influence whistleblower activity and enhancing whistleblower protection.